bit about this, and then I'm going to let Erica continue. Prior to the decision in Wong, it's been recommended that, as I indicated, defense counsel have a duty to advise clients of the consequences of guilty pleas and what flows from it. In the actual criminal code, there's section 606 1.1 of the criminal code, which sets out conditions required for a court to accept a guilty plea. The decision of RVTR in your materials confirms that a guilty plea must be voluntary, unequivocal, and informed. In R versus Fan, the court was asked how criminal courts should deal with unintended or collateral consequences. The Supreme Court of Canada affirmed that the impact of a criminal conviction and sentence on the immigration status is relevant in determining a fit sentence. The impact of deportation and the loss of the right of appeal results in the sentence being disproportionate to the gravity of the offense and the moral blameworthiness of the offender. As criminal lawyers, it's very important that we establish a record if there are immigration consequences that are on the line, and to make reference to section 723 and 724 of the criminal code. 723 reads, before determining a sentence, a court shall give the prosecutor and offender the opportunity to make submissions relevant to sentence. 724 says the court may accept information, and that would be by way of affidavit or letter form. One of the difficulties in some of the appeal cases that I've looked at, including the case from the PEI Court of Appeal, Kajulek, is that the original counsel did not set out the immigration consequences, did not put that on the record, and that's very important. And that's why Chief Justice Mitchell reduced the sentence in that case. One of the reasons were the immigration consequences from 9 months to 6 months less a day. So that's very important that we as criminal lawyers put that information on the record by way of letter or affidavit. So that's why it's very important that we find out all of the nuances of immigration law. And that was also made clear in another case of Kimpani. The accused pled guilty to charges of assault with a weapon, and confinement, sentenced to 102 days of pretrial custody plus probation. The corollary orders were also imposed. The hearing was conducted. The plea was indeed uninformed because the status was not known to the accused. A very important principle that was mentioned in the case going forward, I would think that counsel, duty counsel, and immigration authorities in the court where the need is apparent, for example, where the person was self-represented, would need to be well advised to have the immigration issue inquired into. So even judges where individuals are self-represented, I've spoken to judges, and that's very much front and center in their minds about immigration consequences, and they will go under 6 months if it's going to mean that the person will not, their status won't be jeopardized to remain in Canada. Eric is now going to discuss 6 decisions of the BC Court of Appeal in R versus Wong, which she is very familiar with, and I'll let her go ahead. Thank you.
And so I won't go into too much detail about all those cases, but I wanted to highlight some of the different ways that if you encounter someone and immigration consequences weren't considered for whatever reason, if it was, you're dealing with them on a new criminal charge and you notice in the past something happened and, these consequences are already flowing, you could get a 684 appointment. I don't know if legal aid covers these appeals, but if not, the Court of Appeal does appoint counsel and they counsel to represent the person in appeal like this. And so we've had similar cases out in BC, and I think the jurisprudence is finally more consistent on this across the country, where sentences are reduced where it was an error in law for immigration consequences not to be considered by the court, whether Crown didn't raise them or defense counsel, or the onus is kind of on everyone to raise these consequences. And so in R versus Kutsongo, that's a more common example where sentences are reduced from 6 months to 6 months less a day pretty easily. And so in this case, we had Crown's consent to reduce this. We had Crown's consent to the application for an extension of time, even though a long time had passed since the conviction and sentence were imposed. So we submitted an affidavit as to when he first became aware of these collateral consequences, and then that he acted diligently after that to get advice to bring the appeal. And so if they're ever fighting, you can use this as a case where Crown thought it was in the interests of justice in accordance with the duties of their job to consent to this, given the interests at stake. But we've also been more creative in other cases that I think you might be able to use in other cases. In R versus De Aquino, he had a 12-month sentence, and that's a bit long to say that the judge, that you're going to reduce a sentence that much to account for immigration consequences when 12 months is a fit sentence. But we were able to look at the decision and see that there's other things that weren't really taken into account in the sentencing, and in that case, it was the gap principle. And I don't know how much I know that the courts decide things a little bit differently in provinces, but the idea is that if there's been a long period without offending, that the offender should get some benefit for that period. And in BC, it was considered an error not to consider that and the immigration consequences, so the court reduced the sentence to 6 months less a day. But then there's an example of a case that our office didn't do, where someone tried to reduce the sentence of 3 years to 6 months less a day, and the court just said, absolutely not, we're not going to skew sentencing for these reasons. And that's consistent with the decision in R versus FAM. Other ways that we've been able to fix the immigration consequences is an example of R versus Zhang. It's in the past, the courts wouldn't apportion how they're accrediting dead time or how they're accounting for the imposition of a sentence where there's multiple offenses. So they would just say, I'm imposing 6 months total or 1 year total, but a person has multiple charges or offenses that they've pled guilty to or been convicted of. And so we asked to appeal in a way that would clarify the apportionment of that time, so that rather than getting a 7-month total sentence for an assault and uttering threats, that it be divided up so that the immigration consequences could have been avoided. And we actually lost that one at the BC Superior Court, but then on appeal, they considered that this all should have been apportioned in a way that accounted for immigration consequences. So the sentence was varied to 4.5 months sentence on each charge. And then R versus Gonzalez was a really interesting case where I had actually lost this issue before the BC Superior Court, where somebody got a sentence of, it was over 6 months, but then the law changed in 2012 to change the appeal rights from 2 years to 6 months. The BC Court of Appeal agreed to reduce a sentence that accounted for the immigration consequences before the change in the law, even though at the time of sentencing, no one could have known about these immigration consequences necessarily. I think the idea was that had been close enough that legislation had been tabled, so there was some awareness that this would be a consequence in the future and that this could change, and no one discussed it. So, I lost this issue before the Superior Court, where they said, absolutely not, how can we impose a duty where no one knew for sure that was the law? But the Court of Appeal disagreed in that case and reduced the sentence, yes.
I see that these cases must have been taken through the administrative tribunal phase to then the Superior Court and the Court of Appeal. Are these project clients, or is immigration law funded in British Columbia?
So these are conviction appeals, and so they, as a matter of criminal law, they're funded by legal aid. The triggering moment was that what I talked about yesterday, a Section 44 report. So they became aware that an immigration consequence would result and immediately sought legal advice. What do I do? This is a mess. And then we, from that moment on, filed the notice of appeal to appeal the conviction in the BC Court of Appeal or the BC Supreme Court. So it's separate from the administrative tribunal process. Yeah, do you know if does legal aid here fund appeals?
Yes.
Yeah. And so, I mean, this is an error in law not to account for immigration consequences. Another case that we did was R versus Reed, where we looked at the record, and so this is why I think there's a big division between people who do immigration law and people who do criminal law, and our office really operates in that nexus. So we've identified a lot of these cases where we look behind the criminal record. I think sometimes acting as immigration counsel, it's easy to just look at the immigration picture, and in criminal law, it's easy to just look at the criminal picture. But if you can understand both, you can see how these problems connect in a way that's quite unfair. So we had this client who was convicted of breaking and entering into a house, into a place. And that's a serious criminal offense because it's got a maximum of 10 years. But we looked behind what he was actually alleged to have done, and he fished coins out of parking meters. So he was breaking and entering into a thing. And then on his record, he had all of these charges and convictions for what is actually a separate offense under the criminal code for fishing. I mean, does it say it there? Yeah, breaking into a coin-operated device. And so it was counsel at the time who just pled him out to whatever was on the record without looking whether or not it mattered that he wasn't actually breaking and entering into a place. And so we got Crown to consent, and this was actually a conviction from 2001. So we were able, Crown agreed to the extension of time, and this guy, like he was a addict, he had a horrible, tragic story, and since then has gotten his life together, and then through this case doesn't have the collateral immigration consequence. So we were able to get the charge changed, and this was a conviction appeal rather than a sentence appeal. But it was the problem that you're going to be up against is that extension of time, and it's through the immigration consequences. And when you became aware of that, that you can get that extension of time, or at least you could in BC, and I'm hopeful that you could use this case law to get it here too. And so then comes Wong, whereas the reason we were doing all these sentence appeals was because BC had this horrible interpretation of the law that to set aside a guilty plea, you had to show that you had a viable defense. So first, that you weren't informed of an important consequence to the guilty plea that you were making, but also that there was some basis to set it aside. So, I mean, everyone who practiced criminal law, and who doesn't, knows that the burden is on Crown to prove beyond reasonable doubt. So it seems logical that if there's some doubt of your guilt, or you have the right to put Crown to prove that burden, but for some reason our Court of Appeal decided you need to show some viable defense that would undo this guilty plea. And so what we noticed then in looking at the cases across Canada is that there was different tests in each province. So some provinces used that test. Ontario had a much better one that didn't require that viable defense. I remember looking at a case from the Nova Scotia Court of Appeal. They had cases going two different ways on this from what I remember, and so that's how we got leave to get the Supreme Court of Canada to look at this, to impose a standard across the provinces. And luckily, they gave quite a good decision for everyone except for Mr. Wong, to allow people, if they weren't informed of that consequence, to set aside their guilty plea. And so, did you want to help talk about what Mr. Wong